Assalamualaikum and good day to Mr. Amir. We are from Messrs. Kothai and kami. Today we will present regarding the topic cost, specifically what cost that will be granted by the court where the defendant had proved prima facie case to set aside judgment in default by plaintiff. Our group consists of me, Akmal Imran, Aina, Hanum, Zini and Kothai. So let us start with our presentation. So for the introductory part, it is important to understand the concept of judgment in default of appearance. JID is one of the interlocutory application that is entered against a defendant when they fail to enter appearance within 14 days from the date of service of a writ or originating summons. However, the defendant can set aside the JID within 30 days from the date of receipt of the JID according to Order 43, Rule 13. And if the defendant application to set aside is accepted by the court, the effect of the JID would be classified as only interlocutory application because the defendant has a defense on merit or the judgment is irregular and it will be brought for trial. However, if the JID was not set aside by the court because the defendant has no defense merits or the defendant does not apply to set aside the JID within 30 days, the effects will be judgment without trial and JID will stand as the final judgment and the costs will be borne by the defendant. And it is worth to note that from conclusion during interlocutory application, the costs given follow Order 59 Rule 21. Meanwhile, for JID under judgment without trial, costs given follow Order 59 Rule 22. The meaning of cost is defined in Order 59 Rule 1, which include fee, charges, disbursement, expenses and remuneration. In a trial, the court will grant orders as to cost to a party to pay for another party at his discretion, and the court has the discretionary power as according to Order 59 Rule 2, Paragraph 2 to determine by whom and to what extent the costs are to be paid. There are various types of order according to Order 59 Rule 1, Paragraph 3. Terms mentioned in the first column of the table under this provision are the terms usually used in order for costs such as cost in an event, cost in the application, cost thrown away, plaintiff cost in the cost or defendant's cost in the cost, and cost paid for forthwith. In this situation, where the defendant had applied to set aside JID and was successful, to whom, when, and what order as to cost granted by the court will be further discussed in this presentation.
Regarding to which party the order of cost for judgment in default JID of appearance should be given, it will be decided according to the discretion of the court and follow the event also as has been stated in Order 59 Rule 3 subsection 2. Usually, a successful party will be awarded costs which are to be paid by an unsuccessful party. These are called party and party costs. Where the event the JID of appearance is irregular or if it is regular but has been applied to be set aside by the defendant and granted by the court since there is defense on merits, both of these events lead to the JID of appearance entered by plaintiff being set aside, but for the first part it will be set aside as of right. It is the same practice as has been ruled in the case of Chinggit Development Sendirian Berhad. It can be seen for this event the unsuccessful party in this event is the plaintiff since his application of JID of appearance has been set aside. So the plaintiff should bear the cost of the defendant and bear his own cost. Term mentioned in the first column of the table under Order 59 Rule 1 when used in an order as to costs that are related to this event are costs thrown away, where it effect indicated in the second column of the same table. Where proceeding or any part thereof have been subsequently set aside, the party in whose favour this order is made, which is the defendant in this event, shall be entitled to his cost of this proceeding or that part in respect of which it is made. However, the principle mentioned earlier just for when the JID is irregular, but if the JID is regular judgment, then plaintiff shall be entitled to the cost and defendant shall bear the cost.
Contrast, in the event of the judgment in default of appearance become final judgment, which led to judgment without trial because failure of the defendant to apply for setting aside the JID within 30 days has been stated under Order 42 Rule 13 of the ROC. Or failure of the defendant to prove the merit of defense or the application to set aside being rejected by the court. The unsuccessful party in this matter is the defendant since the judgment is given in favour of the plaintiff. So the defendant in this case shall bear the cost. The case of White against Westons defines the merit as merely raising an arguable or triable issue such as contributory negligence in a running down case. Moreover, in the case of Yayasan Melaka against Patron, the meaning on merit of defense is where there is a need to raise triable and arguable issues. Terms mentioned in the first column of the table under Order 59, Rule 1, when used in an order as to costs that are related to this event, are costs reserved, costs in any event, costs in the cause, and plaintiff costs. In the cause, since if JID stands in the final judgment, there will be conclusion of the cause. So the party in whose favour an order for cause is made shall be entitled to his cause of the proceeding in respect of which such an order is made. In this part, plaintiff is the one who should be entitled for their cause. So defendant as the one the order is not made in their favour are the one who should bear or paid for the cost.
Today, I'll be explaining on when order for cost will be made and why. A relevant provision for these is under the Order 59, Rule 7 of the Rules of Court, which provides for stage of proceeding at which costs are to be dealt with. Normally, at the end of the trial, other than make decision with regards to the dispute, the court will make an order for the cost. Firstly, the court will pronounce such as plaintiff's claim is allowed with cost or dismissed with cost. In another term, immediately, certain amount of cost to be awarded to the winning party. When such order has been made, the unsuccessful party has to pay the successful party. Unless otherwise ordered by the court, expenditures must be reimbursed after proceedings. After the hearing, the court will decide on expenses. The court shall require that the party's cause submission be presented as part of the substantive submission of the matter or separately with a Forms 117 bill that contains details of the work done, including the value of getting up and any reasonable expenditures. Form 117 is bill of cost used during submission of cost and disbursement. Moreover, the court considering an appeal may handle the expenses of the process that led to the appeal and the appeal itself. The High Court may handle matters transferred or removed from another court before and after the transfer or removal. For High Court cases, the registrar must provide an allocator certificate upon payment of a fee equal of 4% of the cost or at the Chief Justice's discretion. Two cases that are relevant for this situation is the case of Adesh Pandit against Viking Engineering Sundari and Berhat. Federal Court held that this application for security of cost can be made at any time and not necessary to file at the earliest opportunity. In the case of ACO against K Limited, the proper time to apply for security is at the early stage, and it went on for an appeal, a question of strict compliance with timetables. It was held that time is of the essence in the course of action.
For the application, it can be based on the case of Alliance Bank Malaysia Berhad against Arita Plastics Industries. It provides that when considering an application to set aside a judgment in default, the first task is to ascertain whether it is a regular or irregular judgment. If it is an irregular judgment, then the default judgment ought to be set aside as of right. If it is regularly obtained, the court has to determine whether a defense on the merits has been shown. In the case of Yayasan Melaka against Fortran Corp, the court explained that a defense on the merits is when an arguable tribal issue is raised. As provided, the general rule is that when making an order for cause at the end of a trial or proceedings, the court shall follow the rule, court shall follow the event, which provides that the losing party pays the winning party's cost and the losing party bears his own cost. In the current situation, where the judgment in default is set aside, is cost thrown away. This is where, for example, a judgment order is set aside, the party in whose favor the cost is made is entitled to the costs which have been incurred as a consequence. This includes the cost of preparing for and attending any hearing at which the judgment or order which has been set aside was made, and any steps taken to enforce a judgment or order which has subsequently been set aside. In the current situation, the plaintiff entered a regular judgment in default of appearance against the defendant. The defendant applied to set aside the default judgment. The default judgment was set aside by the court on the ground that the defendant had a prima facie defense to the plaintiff's claim. The said judgment is regular, and the default judgment was set aside by the court on the ground that the defendant had shown there is a tribal issue.
It can be observed that the plaintiff's judgment in default was set aside, which provides that the plaintiff is entitled to the cost.
So it can be concluded that the order as to cost that is likely to be made by the court in the current situation is cost thrown away, which provides that the cost shall be borne by the defendant.
Because the judgment in default is regular.
After a thorough and insightful discussion by all of my group members, we can conclude that firstly, in determining the order of the cost, it is all up on the discretion of the court to decide. The order varies based on the circumstances of the case. Hence, in this situation where the defendant has successfully established a prima facie case to set aside judgment in default by the plaintiff, the court may grant order costs thrown away to the defendant as he is entitled to his cost of the proceeding, as stipulated in the first column of the table under Order 59 Rule 1 Paragraph 3. But this only applies in the situation where the judgment in default is irregular, since if it is a regular JID, defendant should bear the cost. I think that's all from us. Thank you, sir.